Good afternoon. Judge Tom Greenholz is to my right, Judge Kyle Hickson to my left, and I'm Bobby Holloway. Ready for the afternoon docket. You ready to call the first case?
Yes, Your Honor. State of Tennessee versus Roy Garrens, Jr.
Jones?
Afternoon, Your Honors. Kendall Jones for the appellant from his appeal from the Fayette County Circuit Court. Judge Holloway, may I reserve 4 minutes for rebuttal?
4 minutes, yes.
Your Honors, we've raised 3 issues in our brief. Unless the court has any specific questions about issue 1, which is the sufficiency on one of the convictions, we'll rest on the arguments made in our principal brief. We would ask, the state has conceded in count 2, and we would just ask the court to accept that concession. Most of the discussion today that I'll be focusing on will be issue 3, which is the foreign convictions test that was done at sentencing.
Counsel, can I ask you about your first issue?
Yes.
And I know we're not spending our time on that, but could you respond at least briefly to the state's argument that the appellant's argument may be inconsistent with the Sentencing Commission comment or the Advisory Commission comment?
Oh, yes. I have no, the Advisory Commission comment that says even if there is a weapon that is not, the person does not see the weapon, that it may still support that conviction.
Yes.
I will just respond that this was an issue that my client felt very strongly about.
Counsel, I appreciate it. Thank you.
Yep.
Okay.
Just to set up the third issue briefly, Mr. Garrens in this case had at sentencing 2 prior convictions that were, under the state's argument, considered to be felonies. They were out of a jurisdiction that was not in Tennessee. And at the sentencing hearing, Mr. Garrens, or counsel for Mr. Garrens, agreed that on 1 count, which was aggravated assault, which is a Class C felony, he was eligible for sentencing at range 2. We have argued in our brief that the trial court erred when it sentenced Mr. Garrens at range 2. It did not perform the foreign convictions test. So the question probably right out of the gate is, why are we now arguing on appeal when we agreed to sentencing at that range? The trial court, much like some other issues, such as jury instructions, or in this case sentencing, the trial court has a duty to make certain findings. And when we review these on appeal, whether or not they agree on an issue, the trial court has to make those findings nevertheless. It's the same as me coming before this court and asking it to accept the concession in count 2 or in issue 2 of our briefs. We make the arguments, but the trial court, this court's duty to make an opinion or a ruling on it is separate and apart from anything that we might agree upon.
Is there a question of estoppel? So I know you all are familiar with State versus Ross dealing with the risk and needs assessment issue. And in State versus Ross, that panel made a distinction between affirmatively waiving something such that you really couldn't raise it on appeal because you were stopped to raise it on appeal. It was a preservation of essentially of the judicial system. We're not going to allow counsel to play games with, and that's not what's happening here, but we're not going to allow counsel to play games with the court. If you have an agreement in the trial court that range 2 is the appropriate range, or just we're going to allow you to be sentenced in range 2, if there's an agreement to that effect, not even just the absence of an objection, but an agreement, why shouldn't estoppel principles come into play?
Well, this court, if this court found that to be the case in this case, it would go against its earlier decision in State versus Bobby Marable,
okay,
which was the exact same case. I handled that case for our office, almost identical situation. Mr. Marable's trial counsel agreed to sentencing at that point, and in that case, the state conceded that it was error for the trial court to sentence Mr. Marable at range, I believe 3 it was in that case. He had 1 conviction that would have taken him from a range 2 to a range 3 offender. That case differs from this case, and that opinion is also interesting in that the state conceded that Mr. Marable's case should go back to the trial court for resentencing as a range 2, but the court really didn't address the standard of review on whether it was plenary or plain error. It just accepted it. Now, I know this court has kind of gone back and forth on some of these issues. State versus Gordon comes to mind, but we have argued plain error in this case out of an abundance of caution, but that would be my response to the estoppel issue. This court has, even though it's found that it would be a waiver or something of that like, it was necessarily still available for relief under plain error, and plain error relief was granted in State versus
How's the
Bobby Marable.
situation different from when you're entering a plea, the defendant agrees to an out-of-range sentence? So at the sentencing hearing, you come in and to say it's an open plea, but we agree that he can be sentenced in range 2?
Well, in that case, in a Hicks plea, if that's
Right.
what the court's referring to, there's a colloquy between the defendant to understand what's going on. There's not necessarily that same colloquy that's going on with a defendant during a sentencing hearing, and it doesn't appear that there was one in the sentencing, at the sentencing hearing in this case. So is the court insinuating that someone can agree to plead out of range or agree out of range at a sentencing hearing the way they can at a Hicks plea for some kind of benefit?
I'm insinuating nothing.
Okay.
What I'm suggesting is that the law allows a defendant to waive sentencing in an appropriate range. So in a Hicks plea context, for example, I may be a range 1 offender, but for the purpose of resolving the case, I agree to be sentenced in range 2. Going back to our earlier discussion, in the context of a full sentencing hearing, where it's not just an agreement as to the appropriate sentence as part of a plea agreement, but in a sentencing hearing, I was wondering, why wouldn't the same principle hold? I can agree that for the purpose of a sentencing hearing, the court can consider my range, I don't know, peg it 6 to 10 on a Class C felony, even though I'm range 1.
I'm tracking now. I don't think there's anything necessarily wrong with agreeing to range at a sentencing hearing like this. The problem then comes, and the same thing with the trial court has the same duty as a Hicks plea as it does at a sentencing hearing, and not necessarily the same factors that it has to go through, but the trial court has a duty independent of what's being discussed between the state and a defendant or counsel to make sure that everything is above board. That's no different in this case. The trial court has to make sure and has that duty, even if we've agreed at the sentencing hearing that a specific range is appropriate for one of the counts, that still doesn't alleviate the trial court from its duty to make sure that the state has met its burden beyond reasonable doubt that it has proved range.
Does it not, though? I mean, I hear what you're saying, but from a practical standpoint,
Yes.
You're a trial judge, you're sitting there, you've looked at this PSI, you see these 2 convictions from Odessa County or wherever they're at, and then the parties come in and both say that he's range 2 on this offense. I mean, as a trial judge, are you really going to say, no, stop everything?
And I'm not unsympathetic to that. And in fact, I think most of us who have practiced in trial court appreciate a trial judge who trusts attorneys on both sides to come to an informed decision and accept that. And I think the jury instruction is what I always come back to. Even if we agree pre-trial on a set of jury instructions, that if we're reviewing it on appeal, the burden is still on the trial court, or the duty is still on the trial court to make sure that the jury has a full and fair charge for everything that they need to make the decision in the case. So I'm not unappreciative of the fact that the trial court was willing to do that, but it's an entirely different consideration now that we're here on appeal. If those 2 have agreed, the trial court still has to make those findings, or it's up to the trial court at that point whether or not it wants to accept that as true, or whether or not it looks at those convictions and sees 2 unfamiliar counties, Ector County Court or 358th District Odessa, and understands those to be not counties or not jurisdictions in Tennessee. That's the trial court's call whether or not it wants to further investigate. Same as if it's taking a plea and it wants to make sure that all of the parties are satisfied before a plea is entered.
When the
Go ahead.
defendant, again, concedes that he's range 2, why can't the trial court take that as a concession that this, say, the escape in Texas is a felony?
Well, it's the same, it's no different than here. Whether or not the trial court wants to take an exception, it's up to this court whether or not it wants to take the concession from the state, the argument that we have in issue 2 here. The discretion still lies with the trial court, and then that's what comes in on appellate review.
I wonder if the analogy to the jury instructions is the right analogy. So let me ask you about a different analogy. What if, during the trial, the state and the defendant stipulate as to a fact? They reach agreement as to a fact. Now, the criminal court jury is not bound to accept that fact, but the parties are, and the parties are bound to it. And we don't come back on appeal and allow one of the parties to come out from under its own stipulation. Isn't that really the more analogous situation here, a stipulation at trial versus a stipulation at sentencing?
No, I don't think so.
Okay, how so?
And I think, to that end, it's going to depend on the kind of fact. Say for like, I think probably the most relevant one that I can think of.
Is a felony status. A felony status. A defendant will stipulate a lot of times in a felon in possession case that the felon has, or excuse me, that the accused has a qualifying felony conviction.
Correct.
The jury may consider that or may not consider it, but we don't typically hear on appeal a challenge to the stipulation the defendant has entered into.
Well, and then that would be, I take it as, think of it in the context of a DUI. We can stipulate to blood alcohol. Oftentimes the state won't accept that stipulation because they want the person from the TBI perhaps who is doing the blood alcohol test to be able to testify as to the effects of what is going to happen when someone has a 0.2 blood alcohol
Let's
for some
consider a
instance.
situation where both parties do stipulate. And in my hypothetical, we're stipulating to an element of the crime, something that the state otherwise would have a constitutional duty to prove beyond a reasonable doubt. If we allow that to happen at trial, why wouldn't we allow that to happen at sentencing, where the parties stipulate that the out-of-state convictions are qualifying convictions for range 2 purposes?
Well, that still has to pass through the lens of the trial court. Parties can't stipulate, I would argue and counter that parties cannot stipulate to any fact they want to without the trial court first approving it for something for review for the jury to hear, correct? That would be a felon status. In your example, I think someone stipulating to the fact that they're a felon on perhaps, say, a felon in possession charge. All that does is expedite the trial process. They can't just have a stipulation outside of the consideration of the trial court and just present that to the jury. The trial court still has to, under its reviewing lens of what is admitted as evidence or what is admitted as a stipulation, the trial court still has to accept that. If we both stipulated, if the state and I both stipulated, for some example, that, I don't know, we were both wearing red shoes and that was presented to the jury, now that wouldn't be a relevant fact for the trial court to consider, but the trial court would still say, that's not relevant, that doesn't meet the threshold, that's not going to the jury. So I think in that case it would depend on the facts, and again, it still has to go through the filtering lens of the trial court as it does here, would be my response to that. Anything, the court has anything further?
Thank you, I appreciate the answer. Yes.
The two issues that the state has raised with the plain error argument that's discussed in this case focus on two factors mainly. One, that it was a tactical decision, and two, that we have not shown that a clear and unequivocal rule of law was broken. I sat in here on this morning's session in the discussion of whether it was tactical was something that was the burden of the defendant. And it is, absolutely. It's one of the plain error factors. It's a burden that we have. What the Supreme Court has said, our Supreme Court in State versus Gomez and Smith, is necessarily that the absence of any indicia that there was a tactical decision at trial is enough to satisfy that prong. So we still have the burden. Our Supreme Court, to my perspective, has just stated that burden that we have to show for tactics is somewhat low. Absent anything in the record that there was a tactical decision like, oh, Your Honor, we're doing that because of X, Y, and Z, not dissimilar from what a Hicks plea would be. We're doing this so that we can get the benefit of perhaps not being sentenced at a higher class of felony, but keeping that percentage for release eligibility. Specifically, I think the state has argued, and if the court has any questions about it, they've relied upon a case, State versus Jamison, where they have said that by stipulating in this case, Mr. Garrens prevented the state from developing the facts on the conviction, and then may have had some other convictions that maybe the pre-sentence report or anything else the state didn't find. And those comparisons aren't apt, and I'll explain why. First, the state has the burden of proving those prior convictions. Nothing in the record indicates that there were other conditions or there were other convictions. So absent that, we cannot just simply presume that there was some kind of nefarious intent. As the cases I've just quoted from the Supreme Court, absent any indicia that this was done on purpose or a tactical decision, but this court can't find that there was evidence of some kind of tactics. And then the other thing is, the state would still be allowed to develop the facts on these convictions. Those convictions would be relevant for things like consecutive sentencing, if the trial court was trying to find if he had a record that was extensive, whether or not he was a violent offender, would be relevant for enhancement factors. So merely stipulating to range does not prevent the state from not being able to argue or develop the facts of the convictions that it's seeking to use for range. And the other argument that the state has made concerns the clear and unequivocal rule of law. Where this case differs, I think, from Marable, as I mentioned before, is the record here is not sufficient to develop, the record here does not have enough in it for this court to conduct a foreign convictions test.
Is that a problem for the appellant under a plain error analysis, though?
No.
Well, the reason I asked that, let me flesh that out just a little bit. The reason I asked that is because it may be one thing in the trial court for the state to have the burden to put on sufficient evidence to show that the foreign conviction is a qualifying felony. In the absence of an objection, if you're on plain error in the appellate court, it may be that the burden is on the defendant now, under a plain error review, to show not only that there's a clear and unequivocal rule of law that's been breached, so now the state doesn't have to prove anything, it's on the defendant's burden, and to show that there's a need to do substantial justice. And that, I think, would require the defendant having the burden, now coming before the court with the proof that the foreign conviction does not qualify as a Tennessee felony. So while the burden may have been on the state in the trial court and the appellate court, I wonder if that burden is yours, and if the admission is that the record does not allow us to make that determination, do you lose?
If I understand the question correctly, the court is asking whether or not us agreeing to range prevented the development of a record that we now argue is insufficient.
That's right, on plain error where we all agree you have the burden.
And I would say it was not. First, the burden lies with the state to prove range.
At trial.
At trial.
Or at sentencing, right?
Yes. On review, under plain error, well, first we found that there was abuse of discretion from the trial court. It was supposed to find, under sentencing, it was supposed to find that the state had established beyond a reasonable doubt that the range classification was appropriate. Once we get to appellate review, we find that that is not harmless because it resulted in a longer sentence. And it may be a moot point because all of the counts were run concurrently with a much larger count here, including the one that is at issue in this case. But the third point to that is, even if the record is undeveloped, even if the state, or even if this panel finds that it takes judicial notice of these foreign convictions, that they were out of Texas, and even if it conducts the analysis, the state's own point. Part of the point of foreign convictions is whether or not something was an out-of-state conviction, could have been a felony or misdemeanor at that time in that state, or could have been a felony, and could have been a felony in Tennessee at the time. And by the state's own admission, going through the fact that the trial court didn't conduct, even though we agreed, the trial court did not avail itself of its duty to make sure that range was established, even if we go through the judicial notice, which is supposed to be something that is so obvious that it is just presumed that people know it, which we argue is not 38th Judicial District, Odessa, or Ector, even if you get to that, the state's own analysis of the law in this case is that it could have been a felony or misdemeanor in Texas at the time, and it could have been a felony or misdemeanor in Tennessee at the time. And what State versus Vic tells us is, in that instance, when you have something where you do not know where it would have been a felony or a misdemeanor, you have to have the factual basis upon which the plea was made, which would be a transcript, essentially, of the convictions. And we don't have that here.
And so that's something that could never be waived by the defendant. The defendant could never waive the trial court's independent determination of a qualifying conviction.
It can be waived, but I think it's still available under plain air relief, if that's what the court said.
Thank you.
And I see I've gone into my time. Thank you.
Good afternoon, Your Honors. May it please the court, Davey Douglas on behalf of the state. This court should affirm the defendant's convictions for especially aggravated kidnapping and aggravated assault, but the state does concede that a remand is warranted to merge the conviction for aggravated kidnapping into the especially aggravated kidnapping. And the defendant is not entitled to plain error relief on his sentencing claim. And like my friend on the other side, I will, unless this court has any questions about the first two issues, the state would rely on its brief as well, and I'll just jump right into the sentencing issue here, where it's the defendant's burden to establish plain error, and it's a burden that he cannot meet here. This has really sort of been alluded to with some of the questions and the hypotheticals, but what we had here was the defendant conceding to the trial court that he was a range 2 offender. And it was reasonable for the trial court to rely on that concession and sentence him accordingly. And this is, Judge Greenholtz, you were sort of pointing this out, this is really analogous to the parties stipulating to something in the trial court and that being submitted to the jury. This is what the parties did here. They basically stipulated that the defendant was a range 2 offender, and he can't then come up on appeal and raise the issue for the first time and establish plain error.
Let me ask you this. Based on the record, the only way he could be a range 2 offender is that if the Texas escape was a felony. Is that correct?
That's correct, Your Honor.
And so he'd be a range 1 offender if the Texas escape was a misdemeanor.
Yes, Your
So
Honor.
the state's position, by stipulating that he's a range 2, indirectly stipulated that it was a felony.
Yes, Your Honor. That's correct. And again, what makes this case very distinct from cases like State versus Maribel and State versus Gordon is, as the parties essentially seem to agree, there just isn't enough in the record here to establish that the Texas escape conviction is not a felony. And that's the burden that the defendant has to show plain error here. The reason that this court reversed in Maribel is because there was sufficient evidence. The state conceded that Mr. Maribel had a Georgia conviction that did not qualify as a felony in Tennessee. And then in State versus Gordon, the parties had agreed Mr. Gordon, I think, was a range 2 offender, but the trial court sua sponte found that he was a range 3 offender. And this court concluded that was error because it had the prior Michigan convictions and concluded that they were not felonies in Tennessee. We just don't have that here, and that is the defendant's burden to establish plain error. It may have been, and it certainly is, the state's burden below, but now that we're here on appeal, to show that he is not a range 2 offender, the defendant actually has to have some evidence of that, and that's just a burden that he cannot meet here.
So your friend on the other side noted that all of the convictions were concurrent. This is the sentence with respect to this particular charge is shorter than the longest sentence. Even if we were to grant some kind of relief, does the effective sentence change by even a day?
No, Your Honor, it does not.
What about with respect to release eligibility?
No, Your Honor, I don't believe that it does, just because his longest sentence is that.
100%, right?
Yes, Your Honor.
And so where is the need to do substantial justice here if whatever relief we grant would not affect the sentence by even a single day? Is there what possible a benefit could come from any kind of ruling that we would hand down?
I think that's a very fair point, Your Honor, that this isn't necessarily a case where changing the sentence is necessary to do substantial justice because it's not going to affect at all the length of the sentence. So that would be another plain error factor that the defendant can't satisfy. Another one where he falls short is whether this was a tactical decision or not. And I know there was some discussion earlier about the Supreme Court language and absent any indicia of whether a decision was tactical. We do have some indications here that this was a tactical decision. You had counsel argued trying to downplay the defendant's criminal history. That very well could have been in hopes that the judge would impose concurrent rather than consecutive sentences. And it looks like that was a successful tactical decision here, as the judge did impose concurrent sentences. There's also an incentive to minimize these prior convictions, like there was in State versus Jamison, especially when one of them is a conviction for escape. That's probably something that an attorney tactically would want to keep away from the attention of the trial court if possible, and agreeing that the defendant was a range 2 offender was certainly a way to do that here.
So by stipulating that the defendant qualified as a range 2 offender based upon the out-of-state convictions, you're saying that essentially prohibited, or essentially got rid of the need to prove up the facts of the underlying case? And so therefore, those facts did not become at issue in sentencing?
Yes, Your Honor.
Okay.
And that's something this court sort of pointed to in State versus Jamison, is that these stipulations, the state's entitled to rely on them and then choose not to present more evidence. And that's not something that then leads to the conclusion that plain error exists on appeal simply because the state took the defendant at his or her stipulation or concession. And what we have here is the state reasonably relying on the defendant's repeated multiple assertions that he was a range 2 offender. And again, based on the record that we have before us, there just simply is not enough here to show that both of these convictions are not felonies. They wouldn't qualify as felonies. There's not enough to show that the defendant is not a range 2 offender, and so he cannot establish plain error here. And unless there are any further questions, we would ask this court to affirm his sentence, but acknowledge that a remand would be appropriate to merge the aggravated assault conviction into the especially aggravated assault conviction. Thank you.
Rebuttal?
Well, I'll speak first to the court's argument that has now raised a third problem with the plain error, and that substantial justice is not necessary to be done because the trial court happened to run all of the sentences concurrent. The damage here is to the procedural requirements that the trial court is obligated to do by statute and under case law. Trial courts may not, although we always encourage, I think as a matter of a practical manner, when things can be agreed upon and when people can agree and speak with each other in the trial court, and they can agree on things in the need for judicial economy, that can be a good thing. That does not relieve the state of it, does not relieve the trial court of its burden to find range. And finding that just because there's no harm, no foul in the facts of what happened at the sentencing does underlying damage to the procedure that is required, that the state is still required to make that burden that they prove range beyond a reasonable doubt.
Isn't that the very essence of plain error, though? Because on plenary review after a proper objection, you're right. We examine those things. But on plain error review, where you have the need to show a clear, a breach of a clear and unequivocal rule of law, and that it actually had an impact on the proceedings, you may have an error here. Procedural error may be important, but if it had zero impact, and I'm not sure that it does. That's why I asked your friend on the other side. But if it has zero impact and doesn't reduce the sentence by a single day, doesn't affect the length of time that he would serve or the time that he would be out on parole, doesn't affect it at all. Under plain error, under that fifth factor, that seems to be something that has weight.
That's looking at it in the lens of a single case. What this court will decide if it
Which
does
is what we
this,
have to do, right? Under the fifth factor is looking at this single case.
well, then the court is going to be saying that every single case that goes forth, it doesn't matter if procedure is violated in the trial court.
What we'd be saying is, I think the holding would be is that if there's an issue, there needs to be an objection and not a stipulation.
Well, that case law has already been established. I believe in Gordon, this court said that there has to be, not only if this is just under trap 3, it doesn't have to be in the motion for new trial, but there has to be contemporaneous objection. There is still damage to this court and to substantial justice if this court finds not just the substance of a particular facts of a case, but that under plain error, a trial court or any other person, it may be a different thing in subsequent cases, but if there is a procedure that is violated and it happens not to affect the person, or they happen to have run all of the sentences concurrent, there's still damage in that, because that sends a message to the trial court that is, as long as 2 people agree, I'm off the hook for whatever responsibilities I may have. Because if they find under plain error, I'm good. I don't have to find that the state met its burden, they agreed to it.
Isn't that the very essence of the harmless error doctrine, more largely? I mean, all the time when errors are subject to the harmless error doctrine, we say, yes, there was an error, but no relief is granted because it didn't affect the outcome of the trial.
There's still-
We're not finding that no error occurred, and we're not saying you can go forth and err all you want to. We're just saying in the context of this particular case, we cannot give relief because the error is harmless. Isn't this just a natural
The
extension of that?
acknowledgement of the error is important and necessary nevertheless, even if there is not relief granted.
Okay, so you could have a holding that says maybe there is a breach of a clear and unequivocal rule of law, but that substantial justice is not required to correct the error?
No. So what the trial court is saying, substantial justice is not just substantial justice for the client. Substantial justice would be to the procedure that is done and is required for every single sentencing hearing that's had. Substantial justice, I don't know of a case that says it's specifically to a defendant's case, but necessary to do substantial justice is not just in a particular defendant's circumstances, it's to the system as a whole.
Thank you, counsel.
Thank you.
Counsel.
Thank you all.
All right. All right, call the next case, please.